Brothers and sisters, friends, enemies, and neutral. Last time I talked about my background, a very small part of it, in terms of the role that I had played in the legislature by being willing to talk bills to death, standing alone to fight bad legislation, the activities of some senators to try to shut me down. Now, I didn't go into all the detail, but one of these times I am. What I'm going to deal with now is the abortion issue itself. That's what I touched on last time and pointed out that women comprise a majority of the population, and in getting their interests taken care of, they don't have to carry picket signs, walk picket lines, just vote. And they need to vote in women, not just because they're female. Just like Black people need Black representation, but not Black people just because the person is Black. Because in the same way there are Toms, Uncle Toms, and sellouts among Black people, there are simple-minded, silly white women who will go against the interests of women in general to get along with white men who have no respect for them. So abortion is where the rubber hits the road. There are any number of reasons that a woman might want to obtain an abortion, and the person doesn't have to be old enough to be accorded the status of a woman in terms of maturity and age. There was a 10-year-old girl who was impregnated by a grown man, and in the state where it happened, she could not get an abortion. So thanks to the legislature, dominated by white men and supported by, I'm sure, or it's possible, white women who were in that legislature. So the little girl had to be transported to another state where an abortion was allowed. That's one of the very bad situations that resulted. Medical care in general, across the board, is less available to Black women than any other racial or ethnic group. When it comes to an abortion, Black women will be affected far more than any other group. See, there are reasons for a woman to get an abortion other than the fact that she doesn't want to have a child. There are physical considerations. There are, yes, economic considerations. There are social considerations. And before you say, well, those aren't important, think of how many things you do because of those very considerations, how other people think, what society demands, and so forth. But the main thing, these women who are so what they call pro-life don't expect themselves or their relatives to fall into a set of circumstances where they need an abortion. Why do I say need an abortion? People will say, the so-called pro-lifers, nobody needs an abortion. They believe that even if a woman is raped and impregnated, she should not be allowed to get an abortion. She has to carry the fetus of the abortionist, of the rapist, to term. And there was even one state where a woman who had been raped and had a child was ordered by the court to let that child visit the rapist, who was his father, in prison. You see the degradation visited on women? I do, even if women don't. And there are times when an outsider knows what's best for a group better than those in the group know themselves. Well, even when it comes to medicine or nutrition, that often happens. Now, women, because of their superior numbers, need not demonstrate, just vote. Nothing does a politician dread and fear more than a vote. That's why so much is being done around the country to make it more difficult for Black people to vote and even poor white people. Because the vote is the weapon that is bloodless, which is the most powerful in this country. The vote is more powerful than beautiful, persuasive speech. No matter how well I speak, no matter how profound the plays of Shakespeare may be, no matter how much bucking and kicking that Beyonce can do to entertain people, that which carries more power to get something done is the vote. And that's why politicians don't want you to vote, but they think you're so stupid, you won't make the connection between all of their actions to take away your right to vote and the power of that vote. Therefore, they want to take it away. Have they tried to make it against the law for you to wear shoes? No, because whether you wear shoes or not makes no difference. Have they made it against the law for you to live in a 6-room house? They don't care about that. They don't care what kind of car you drive. They don't care about anything. The only thing they care about enough to lead them to undermine the Constitution is the vote. And women are often misled. While I was in the legislature, it fell to me to do more for women's rights than even women were willing to do. I'm just going to mention some things, but not go into detail. I've mentioned before how under the pension program of the state of Nebraska, female retirees did not get the same level of payout that males got, even though they paid the same amount or percentage of their salary into the retirement fund, because it was argued that women, being women, live longer than men, but not every woman lived longer than every man, as I pointed out. But even if she did, the retirement program was built on the principle that a certain portion of a person's income would be taken while he or she is working to make it possible when he or she no longer worked to get a certain payout based on the proportion of their salary that went in. But the women got cheated, and it didn't occur to white men to correct this because it was to their benefit, even though their mamas were women, their sisters were women, their daughters were women, their wives were women, but it made them no difference. A black woman, Cynthia Granberry, who worked with me, was enrolled in law school, and among other things found out that happened, told me, and the black man got it corrected in the legislature over the opposition of white men. And I did it by embarrassing them. When the white female athletes were not given a dining facility like the males, and the males got one because a rich old white man gave money that would build the dining facility and a study area, a bank of computers and everything needed, even counselors for the male athletes. And the white female athletes would eat in the dorms. And I thought that was unjust. It was. And I got the legislature to pass a resolution condemning it, and it was corrected. And even the newspaper of the NCAA, National Collegiate Athletic Association, wrote about it in their newspaper under the headline something like "Action Taken." The white female basketball coach of the female basketball team was paid at a lesser rate than white coaches of the male teams, but not only that, would have the number of people who bought tickets factored into it. And I attacked that immediately. And I drew a parallel between what they were doing to this white woman with what women of the night, as they called them, or streetwalkers, had to do. Her income depended on how many paying or cash customers she got. And I said it was degrading, it was insulting. No university should do that. But the female, being nervous as females are made to feel in a white male-dominated society, accepted the terms of the contract. Oh, and I said that they ought to dress the female basketball players like the girls and young women who worked in Hooters restaurants, did all of those kind of things. And yet I was considered a bad fella. But isn't that the way it always is? When it came to abortion, there were women in the legislature who fought against a woman's right to get an abortion. In 1997, there were several bills before that that were introduced in the legislature. One was called a so-called late-term abortion because the Constitution had given a woman the right to have an abortion. But what was being attempted here was to show that there was a particular type of abortion that was late in the term that resulted in an almost fully formed fetus being aborted when the woman's health was not all the arguments that these so-called pro-lifers talk about, but they're for the death penalty. And I questioned the one who was carrying the bill. And I asked, because it says something about a substantial portion of the fetus is introduced into the birth canal, would a foot be considered a substantial portion? And the guy said yes, because he was trying to consider any way out I was offering. So he's going to go against everything I said. I said, what about an arm? Yes. And I'm creating what was called a legislative history. I read the legislation, I read the court cases that resolve those kind of issues. So I was putting the questions. Here is a letter that was written to me in April, well, to be exact, April 3rd, the year 2000, by the Center for Reproductive Law and Policy, which was challenging this bill that was made law in the legislature, and it was voted 45-1. One person said, no, you're the tide of the ocean, but this far shall you come and no farther. And I was that one. They had even gotten the people who agree with a woman's right to have an abortion to go along with them as a result of what they call a compromise. Now, it's good in politics to be able to compromise if you give a little and take a little, and what is produced is better than what was originally offered, although neither side got everything it wanted. That's the kind of compromising that's all right. But here's the way white people want to compromise with black people and women. He's got a dozen eggs. We have a dozen eggs. He wants to negotiate, as he calls it, until he has 24 eggs and we have no eggs. That's what they call negotiation with women and with black and other non-white groups. Here's the letter that was written to me. And it's captioned, "The Supreme Court and Abortion," because that law was being challenged in the Supreme Court. Dear Senator Chambers, I'm writing this letter of appreciation together with Simon Heller. In preparing the brief of the United States Supreme Court in Stenberg versus Carhart, Carhart was the doctor who performed abortions in Nebraska. We endlessly pored over the Nebraska legislative history on the partial abortion vote. Your courageous, brilliant, and singular opposition created a legislative record that is very important for the Supreme Court case. And this case will be a defining one for abortion rights in the 21st century. Your, quote, voice in the wilderness, unquote, and then in parentheses, 45-1, has provided us with critical evidence disputing Stenberg's newfound contentions that the ban is about just one method, D and X, dilation and extraction, and about just so-called late abortions. In fact, of all the partial birth abortion cases that could have been taken by the U.S. Supreme Court, the Nebraska case is the best for preserving constitutional rights of choice, as your questions expose the deceptiveness of the law. Your defeated amendments provide proof that the Nebraska legislature affirmatively rejected any health, life, or method clarifications. Particularly important are the admissions you got from various senators that the law could cover first trimester abortions, that the word substantial could mean anything, and that the sponsor's descriptions of what is in the bill and the real wording of the law are not the same. Now, that was from a national organization to the only Black senator and the only one who voted no, and the only one who questioned and created a legislative history. Page 2. I'm enclosing a copy of our brief. You will see that the legislative history section is largely one you created by your persistent questions, which white people call a filibuster, a time waster. I call it extended debate. Continuing with the letter. The Solicitor General of the United States also filed an amicus brief on our side. That brief stresses that the Nebraska ban encompasses all common methods, even first trimester suction, and then it gives a page. And Attorney General Stenberg has no authority to now interpret the statute in one narrow way. Even if so, it would still be unconstitutional. The U.S. Solicitor General also argues that because of the limiting way the Nebraska legislature wrote the quote, life exception, unquote, that even dying women in Nebraska cannot get the safest pre-viability abortions. That was established through my questioning and the determination of those people on the other side to be against everything that I asked. And I even offered amendments that would correct the defects that I pointed out, and they rejected every one of them. The last paragraph of this letter. You have a very difficult and lonely job. Your work is not only appreciated, but it also makes a difference in preserving rights. Thank you. Sincerely, Janet Benschuth, Simon Heller. And Black people and others in Nebraska, even to this day, ask, Ernie, what did you ever do while you were in the legislature? I did things that were never done, and people now wish that I were back. Here's the letter, here's the article that the World Herald wrote, because I gave them a copy of that letter. Headline, New York lawyers laud or praise efforts by Chambers. State Senator Ernie Chambers of Omaha is a hero in the eyes of the attorneys who are representing a Nebraska doctor in a historic abortion lawsuit. Lawyers for the Center for Reproductive Law and Policy, based in New York City, said Chambers' solo performance during legislative debate provided a record that will be used to try to overturn the state ban on a controversial late-term abortion procedure. Quote from the letter they quoted that I read. I'll go in and read it so I can just go straight through it. Your courageous, brilliant, and singular opposition created a legislative record that is very important to the U.S. Supreme Court case, Simon Heller and Janet Benschoff said in a letter to Chambers. Quote, in fact, of all the partial birth abortion cases that could have been taken by the U.S. Supreme Court, the Nebraska case is the best for preserving constitutional rights of choice, as your questions exposed the deceptiveness of the law, they wrote. The Nebraska case will be heard April 25th by the U.S. Supreme Court and is expected to establish whether states can outlaw the procedure called partial birth abortion by its opponents. The procedure is known medically as intact dilation and extraction, or D and X. In Nebraska, the law banning so-called partial birth abortion was adopted in 1997. It was challenged in court by Dr. Leroy Carhart of Bellevue, who performs abortions. The Center for Reproductive Law and Policy, a legal advocacy group, is representing him. The letter to Chambers illustrates that there is often a purpose behind Chambers' penchant for long debates and intense questioning. He is, in legislative parlance, creating a record that will be used by courts in the event a law is challenged. Several judges who have overturned state laws Listen to this, you all who ask what Chambers ever did and why does he talk so much? From the World Herald article. Several judges who have overturned state laws have cited Chambers' legislative questioning in their opinions, including the U.S. District Court judge who overturned the state's partial birth abortion ban. Judge Richard Cuff ruled that the language of the law was so vague as to effectively bar other constitutionally protected forms of abortion. The Eighth Circuit Court of Appeals, in upholding Cuff's ruling, concurred, and in both the trial court and the appellate court, my questioning and the answers I elicited were mentioned, and I was mentioned in the court cases by name. That's what I was doing in the legislature, for those who don't know and don't read court cases or even the newspaper. Continuing the article. Chambers' attempts to clarify the language of the 1970 law were cited in the briefs that were filed in the U.S. Supreme Court appeal. He had wanted to insert language into the bill, ensuring that the ban would not apply to any other abortion procedure. His amendments all failed. That was dated April 7th. This is June 27th. Abortion ruling expected this week. People on both sides of the abortion issue have to wait a little longer for the U.S. Supreme Court's decision on a Nebraska case expected to affect abortion rights nationwide. The High Court did not rule Monday, as many had expected. The decision is now expected to come Wednesday. It will be the court's first major decision on abortion in 8 years. When it reaffirmed the core holding of its 1973 Roe versus Wade ruling that said women have a constitutional right to end their pregnancies. Nebraska's case had its genesis in 1997 when the legislature passed a bill banning so-called partial birth abortions, not a medical term, but one typically used by abortion opponents. Nebraska's law defines the procedure as, quote, partially delivering vaginally a living unborn child before killing the unborn child and completing the delivery. The anti-abortion people use the term unborn child. It's a fetus. Nebraska Attorney General Don Stenberg has used the case as the cornerstone to his campaign as the Republican candidate for U.S. Senate. They always make it a political issue. Omaha Senator Ernie Chambers, who cast the only vote against the 1997 measure, predicted the High Court would rule the Nebraska law unconstitutional. Quote from Chambers, the bill is poorly worded and broadly drawn, is so poorly worded and broadly drawn that it will make illegal certain forms of abortion that right now are allowed under the Constitution, Chambers said. During oral arguments in April, 6 of the 9 justices voiced concern over the Nebraska law. The High Court took the case because of conflicting decisions by federal appeals courts. One court struck down the Nebraska law along with measures in Iowa and Arkansas, saying the law was vague and too broad. Another court upheld nearly identical laws in Illinois and Wisconsin. Then, that was June 27th. Then 2 days later, this article in the Omaha World Herald, abortion ruling may lead to more precise legislation. Minutes after the U.S. Supreme Court struck down Nebraska's ban on partial birth abortions Wednesday, Governor Mike Johans and other state leaders were vowing and planning to try again. Johan promised to, quote, take a very close look at the opinion and see if they have given us any hint as to whether legislation drafted differently would pass constitutional requirements, unquote. Justice Sandra Day O'Connor, who provided the deciding vote in the 5-4 decision, provided more than a hint. In a separate opinion, O'Connor gave specific instructions on how a ban could pass constitutional muster. Quote, "A law would be constitutional in my view," O'Connor wrote, "if it precisely outlawed only the procedure known medically as dilation and extraction, or D&X, and if it included an exception to preserve the woman's health." The 1997 Nebraska law included an exception only to preserve the woman's life. The Supreme Court also ruled that the law's definition of the ban procedure was too broad and vague. Senator Ernie Chambers of Omaha was the ban's lone opponent in 1997. He pointed out its constitutional flaws during legislative debate. He introduced amendments, all rejected, that would have helped address some of the high court's concerns outlawed in Wednesday's opinion. Quote, "The reason it is gratifying is that it shows when one person is willing to stand alone for principle, that one person may wind up being vindicated." Chambers said that Wednesday. He said that he had not read the opinion, but that he continues to believe it is not possible to devise a ban of this particular procedure that will comply with the Constitution. "Let's wait and see," he said. Then here's what the Omaha World Herald wrote, June 29th, and it appeared the same day as this article that I read. Court rejects vagueness. Nebraska, and almost certainly some other states as well, found out on Wednesday that vagueness is legal terminology does not pay, especially when the law in question affects a topic as important and hotly debated as abortion, and that's the case today. In a sharply divided 5-4 decision, the U.S. Supreme Court overturned Nebraska's 1997 abortion law, commonly known as the partial birth abortion law. The majority opinion upheld the rulings of 2 lower courts. All 3 judicial bodies held that no matter what the law's proponents intended to restrict, the language partially delivers vaginally a living unborn child, unquote, could also ban dilation and extraction, or D&E, which was my major argument. That's the most common form of second trimester abortion. That flies in the face of part of the 1992 ruling by the High Court, quote, "While states have a legitimate interest in prohibiting abortion, as Nebraska does in most instances, after the point at which the baby could survive outside the mother, prior to that point, they have no case whatsoever. After that point, under certain circumstances, consideration can be given to banning certain types of abortion or restricting how they are performed." On that issue, which was enough on its own to bring down the law, the High Court elaborated with a couple of observations of its own, both stem from its 1973 Roe versus Wade decision. And this is why that Catholic-dominated present Supreme Court struck down Roe versus Wade. No law banning a method of abortion is valid if it prohibits exceptions, quoting from Roe, quote, "inappropriate medical judgment for the preservation of the life or health of the mother." That was struck down by the current Supreme Court. The Nebraska legislature had considered and specifically rejected a health of the mother clause. Another point, the Constitution offers basic protection to a woman's right to choose to terminate a pregnancy. The Nebraska law's broadness, intended or not, imposed an undue burden on that right. Wednesday was not a good day for Nebraska Attorney General Don Stenberg, who saw his arguments repeatedly batted down by a majority. And that was what this current Catholic-dominated Supreme Court struck down when they overturned Roe versus Wade. This is a few examples that the editorial gave of Stenberg's argument. He had contended that a ban on partial birth abortion, medically termed dilation and extraction, or D&X, posed no risk to the health of women. The court pointed to the bulk of findings and evidence, both in the original trial and elsewhere, that say otherwise. In a small percentage of instances, D&X, whatever else one may think of it, does indeed pose the least risk. That's the one that was allowed by the Supreme Court under Roe versus Wade, which was struck down by this Catholic-dominated Supreme Court. Stenberg also contended that any concerns about risk were insignificant anyway, since D&X is very rarely used. The court, in effect, said, so what? The rarity of a medical procedure doesn't provide a basis for banning it. Stenberg said he had officially interpreted the law as applying only to D&X, not to the much more common dilation and evacuation D&E procedure, and his official interpretation should control the argument. The High Court pointedly noted that the Attorney General's views do not bind state courts and probably not county attorneys either, who may have initiated criminal prosecutions on their own. The Attorney General also tried to point to the legislature's 1997 debates in which the term partial birth abortion arose often. Get this. But the court looked at another part of the debates. There, State Senator Ernie Chambers asked, quote, "You said that as small a portion of the fetus as a foot would constitute a substantial portion in your opinion. Is that correct?" To which the sponsor of the bill, David Marstad, said, and he's now the lieutenant governor at this time of writing, "Yes, I believe that is correct." Such debates, as the court noted, hurt Stenberg's argument more than they help it by pointing out how easy it would be to apply the law to D&E, which were legitimate under Roe versus Wade, as well as to the D&X, which they were trying to bring that time. And then the editorial goes on to how many other states may be affected. I may as well read it. It is unclear how many other states the ruling will affect, although 29, in addition to Nebraska, have enacted some form of anti-D&X laws. That's because the so-called anti-abortion people, the Catholics, wanted that D&X to try to ban, by a backdoor route, all abortions. So other states, following the Catholic Church's lead, enacted a bill into law like the identical one offered in Nebraska. But the court made it plain that no such law can stand if, one, it is so vague as to effectively ban all or nearly all abortions, or two, doesn't allow exceptions for the health of the mother. And the Catholic Church didn't care about the health of the mother. They wanted that ban. The court is right. Painful as abortion is to contemplate emotionally, never mind to go through physically, it remains a decision fundamentally for a woman and her doctor, especially in the early weeks of pregnancy. But while in our view, the World Herald's, it ought to be rare, it also ought to be available. Partial birth abortions assuredly are ghastly to think about. They are, as we headlined in editorials in this space 3 months ago, quote, very close to infanticide, unquote. But it is important to note that the court made it plain that it was not ruling out laws restricting such abortions. There just cannot be a nearly ironclad prohibition, which is what the legislature enacted 3 years ago this month. Simply put, in their zeal, the lawmakers overreached. If they still wish to restrict this procedure, they now have what it looks to us like a clear set of instructions on how to do it and how not to. And Chambers laid that out by the questioning, but they rejected mine. And I was the only one who voted no, because I was the only one who read the bill, read the law, and had sense enough, and if it takes courage, to vote against it. Here is an article from 2001, Abortion Doctors, the headline. The legal fees of Dr. Leroy Carhart, who successfully challenged Nebraska's ban on partial birth abortions, will be paid under a law that advanced Tuesday from the second round of debate. Carhart was awarded $159,211 in attorney fees. The fees were part of $896,228 in claims against the state contained in the annual claims bill. And then this other article, May 9th, when the claims bill was enacted, the state will pay legal fees incurred by Bellevue abortion doctor Leroy Carhart during a challenge of Nebraska's partial birth law. The annual claims bill was passed Tuesday by the legislators. Carhart was awarded the money, awarded the attorney fees by the U.S. District Court, the 8th U.S. Circuit Court of Appeals, and the U.S. Supreme Court. And that, brothers and sisters, friends, enemies, and neutrals, came from the willingness that Chambers had to stand alone, the voice crying in the wilderness. I didn't care how many people said that water is dry, water is wet, and I always would say that. They could not make me say day is night and night is day. You know why? Because I am what I am, and that's all that I am. And that I am includes standing for what I believe is right, doing what I believe is correct. If the whole world is on the other side and I'm the only one on this side, I'm going to be on this side against the whole world. And if you stood for the truth, even against the whole world, you were not insane. If you stood against the truth, against the whole world, I was not insane, brothers and sisters. But what has come to pass between 1997 when I did that and 2020 when I was going to be term limited for the second time? Here is the headline of an editorial, and I'll read it. And it's in small print, so I'm going to have to kind of squint. Chambers leaves mark on Nebraska. Journal Star editorial board. A good share of Nebraskans have no clue who their state senator might be, but almost everyone knows Ernie. That would be Ernie Chambers, the longest serving and arguably most influential senator in Nebraska history. Controversial and given to lobbing verbal bombs at those he opposes, from the Catholic Church to abusive law enforcement and other politicians, Chambers has since his 1970 election to represent Omaha's 11th district been a tireless champion for the poor, people of color, those in prisons and jails, the LGBTQ community, and others, rural and urban, who don't have a voice in government. That, Lincoln Senator Patty Pansing Brooks said, makes Chambers a legend, quote, whose voice rose and pierced our hearts at times we failed to live up to the best ideals of humanity, unquote. And in Omaha, Senator Steve Lathrop's less lofty description, quote, a $12,000 state-funded lobbyist for these groups, unquote. Chambers' greatest triumph came in 2015 when the legislature voted 32-15 to abolish the death penalty, then overrode Governor Pete Ricketts' veto of the measure that Chambers had repeatedly introduced for decades. Sadly, the repeal was overturned by votes in 2016, and Ricketts and his daddy put in, quote, close to $250,000 to help get it overturned. He was also the first to envision paying student athletes. His 1988 bill to provide a stipend to Nebraska football players was vetoed by then Governor Kay Orr. In the 1990s, he took an AIDS test to stand up for the LGBTQ community and diminish the stigma. And in the 2000s, well, the 2000s, he shepherded the breakup of Omaha public schools, arguing the district had failed minority and poor children. But his legislative interests extended across the state, from saving prairie dogs and mountain lions to respecting private property rights. Chambers has drawn national attention for decades, called, quote, the angriest black man in America, unquote, by one publication, cited for his national trend setting in a 1980 resolution that withdrew $25 million in state funds from investments in companies that had interests in South Africa. And this year, that would have been 2020, and this year, he was praised for his successful fight to preserve Nebraska's splitting of its electoral votes by congressional district. But given that he has worked in a minority in the conservative Republican-dominated legislature, Chambers' impact has been more in stopping bad bills, often by himself, through his use of the filibuster or simply wearing down his colleagues. Quote, I'm only one person, but one person and the rules can do a lot, unquote, he once said and did. Perhaps the best measure of Chambers' effectiveness came in 2000 when voters approved term limits for senators to, in the view of many, get rid of Ernie. That worked in 2008, but after sitting out 4 years, Chambers returned to the legislature in 2012 for 8 more years. On January 6th, Chambers will become the first senator to be term limited twice, but he may not be done yet. The 83-year-older told the Journal-Star that he might consider coming back, quote, if I believed that I could do something of value to the community that would send me down here, unquote. If he does not return, Chambers will nonetheless have done a lifetime of service for the voiceless, made life better for all Nebraskans, and made the state a more just place to live. And I'm not through. I'm through just about today, but I'm not through talking about things that I did while I was in the legislature, things that people did not know needed legislation to be done, things that people thought always had been done, but had not until I came. So I'm going to continue along that line, not every program, but for now, I'll tell again and again, women and those who respect the right of a woman to control her own body need to vote, vote, vote. And as I paraphrased the canary who was told that the door to his cage was ajar, I'm out of here.
Thank you for watching The Ernie Chambers Show. If you'd like to make suggestions, email us at ewcfacts@gmail.com. That's ewcfacts@gmail.com. This has been an EWC Communication production.